Thank you, Your Honor. Your Honor, we're here this afternoon in case kept in State of Ohio. This is Alan Servar, case number 24-CR001179. We were last here on April 3rd, at which time the defendant entered a written and oral plea of guilty to one count of felonious assault, felony of the second degree in violation of Revised Code Section 2903.11A1. The case was then referred for a pre-sentence report, an investigation, an updated psychological, and a victim impact statement. Those have been completed, and we are here today for purposes of sentencing. Defendant is present today with his counsel, Mr. Chad Mulkey.
Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. Your Honor, he's 50 years old. He's single. He has no children. I did see in his report, he confirmed that he did get an associate's degree in culinary arts, but that was a long time ago, and since then he had been working in construction and roofing, found that to be more to his liking. He'd like to get back into that line of work. Your Honor, he understands that he has to deal with the consequences of this case here. The serious injury occurred to his mother. There's no denying that. He knows that is what happened. Going back to his history, he has significant drug use going back to the age of 14 with marijuana, and then from there cocaine, and then heroin. Particularly opiates seems to be his drug of choice. Most recently, he acknowledges that he has a problem with those. He was trying to get off them, but that problem has not yet seemed to have been dealt with. So he would like treatment as part of his sentence, Your Honor. I'd explained to him the realistic nature of the charge and the consequences in terms of a prison sentence. He knows that may be in his future in light of the circumstances of this case, Your Honor. So we would just ask the court to consider a lower side of a prison sentence if the court deems that is appropriate, citing his lack of criminal history. He would like to someday, if possible, repair his relationship with his mother, get the treatment that he needs. And again, based on his age of being 50 and his lack of history, and then go from that to a felonious assault of his family member, it just seems that it was something that would not be repeated again. Certainly not not in any sort of a consistent pattern or anything like that, Your Honor. So we would just ask the court to consider minimal incarceration time followed by appropriate treatment such as NeoCap, Your Honor. Thank you.
Thank you. Mr. Serrar, you have the right to address the court before you are sentenced. You can say anything you'd like. Is there anything you want to say at this time?
I've already spoke with my mom. She knows. She's already even told the detectives that this would never happen. I was going to the methadone clinic. This wasn't drug-induced. I was going to the methadone clinic. I was getting 140 milligrams of methadone, and I figured out a heavy narcotic. And I was flunking every drug test, and they didn't say anything for 8 months. So I had this one morning, I said, I'm not even doing the methadone anymore. Stopped cold turkey. Didn't sleep for 10 days. Mental police picked me up, running up and down the street. They took me to an intensive care mental hospital for 7 days, where the doctor even said I wasn't ready. This is all video evidence of me not sleeping. And then 2 days after I left the mental hospital, this happened. And even when I was at this jail, I'm on camera not sleeping. This wasn't drug-induced. This was from lack of sleep-induced. I would never, all the years I would never harm anybody, let alone my mom. And she even told the police that. She's like, she knows this isn't me. And I mean, I'm at a loss of words. I'm heartbroken. I mean, like I said, I mean, you've seen a lot of people here, Your Honor. You have high power perception. You'd have to make your own judgment, but I'm heartbroken over this.
Thank you. Mr. Mulkey, anything else you care to say?
No, Your Honor, not at this time. Thank you.
Ms. Linden for the State of Ohio.
Thank you, Your Honor. Your Honor, as I indicated in Chambers, the state is recommending a prison term. As I stated, there aren't many cases these days that because I've been doing this for as long as I have, that I actually look at a photo and gasp, and I did here. This is and I know that the on-call prosecutor that was involved in this as well, these types of episodes. And so in looking at protecting the victim in this manner and protecting the community at large, and looking at there's been some aggression that he's had within the jail. I know that a number of the incidents that he had were prior to him going to North Coast, but blaming stopping his medication, that's not what it is. There are serious issues that need to be addressed, and a prison term is definitely appropriate here. He does have 216 days of credit for time served, and we would ask for the forfeiture of all the marijuana, the foil package, the plastic bag, the metal can, the rolled cigarettes, rolling papers in the glass jar. But I just don't see any way that, based on the injuries here and based on the severity of this offense, that community control would be appropriate. Perhaps at some time at a later date when the defendant understands that there are serious consequences for his actions, maybe at that point in time, that's something to consider down the line, but not at this point in time. Thank you.
Competency evaluation that was earlier prepared in this case, the victim impact statement. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here in court by the defendant, his lawyer, the prosecutor, the recommendations from the parties. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911. I've also considered the factors under 2912 that indicate the conduct is more or less serious, as well as recidivism factors. As far as the seriousness factors, the court finds the victim in this case suffered serious physical harm as well as psychological harm. And I recognize serious physical harm as an element of the offense, but the serious physical harm caused by the defendant and suffered by the victim in this case is much, much, much greater than what we normally see in a felonious assault case that deals with serious physical harm. I mean, serious physical harm is such a wide range of harm, quite frankly. You could have somebody that gets hit and has a scar. That's serious physical harm. The nature of the serious physical harm in this particular case, that is not guaranteed, that based on your conduct in prison, but a presumption that you will be released after you've served the 4 years. Again, that could be rebutted by the Department of Rehabilitation and Correction if at a hearing they are able to establish that while you are in prison, you basically didn't follow the rules. You committed institutional violations, you're not sufficiently rehabilitated, you still pose a threat to the community, toward others. If that determination is made, then you would not be released at the, and you have the right to be there at that hearing. If they can only do that if there's a hearing and you have the right to be there. But if they make that decision, then you would not be released. They would set another date for you to be released, and there'd be a presumption that you'd be released at that other date. That presumption can again be rebutted if again they proved that you are still committing violations, not behaving yourself, not rehabilitated, still pose a threat. Under no circumstances, however, can you be kept in beyond the maximum sentence. Even if you misbehave the whole time you're there, they have to release you after you've served the maximum sentence. I further need to advise you that while you are in prison, you are entitled to earn good time credit. And there is a presumption, and if the prison officials, it's anywhere from 5 to 15%, if the prison officials find that you are entitled to that, they would notify the court. There's a presumption that I would have to approve that good time credit. You only get it if the court approves it. There's a presumption that it should be approved. If I wanted to disapprove it, you would have the right to have a hearing here in court before that could be disapproved. Otherwise, it would have to be approved. I think that covers everything. Is there anything else? Count 2 will be dismissed. Is there anything else for the record, Ms. Linden?
And just the forfeiture that we talked about, Your Honor, at the time of the change of plea.
It's all just drug paraphernalia?
Yes.
Any type of drug paraphernalia and drugs will be forfeited.
Thank you, Your Honor.
Mr. Mulkey, anything else?
Your Honor, I didn't hear of it, so I'll just bring it up. Is there any restitution on this?
I don't believe. Let me check the victim impact statement again.
I was not advised of anything, but if there's something in the victim
I'll
impact
check right
statement.
now. Got several today, and I want to make sure I don't miss it, but. No restitution. None that was provided in the victim impact statement, and nothing presented by the state.
No, Your Honor.
Thank you, Judge. Just double checking.
Okay, thank you.
All rise.